Thank you everyone for joining us. I just wanted to quickly remind you, this is one of our Sidney seminars, our new series looking at places of democratic and constitutional churn around the world. And as part of the seminar series, we are happy to welcome experts from various regions to talk to us about what's going on. It is a comparative project. As such, we will often have people for whom English is not their first language. We are incredibly delighted by that because we are learning from deeply contextualized experts. And so, as always, we will work to communicate well, and are very grateful that you're presenting in English for us, which is generous, especially for someone like me who is an embarrassment to the field without multiple languages. So I will work on that. And so it is my pleasure first to introduce the chair for today, Natalia Cerda, who is our PhD student here at UCL, and she will be chairing the seminar and introducing our speaker. Welcome.
Thank you, Erin. Thank you, everyone, and welcome to the second session of the Sidney Seminar Series here at the Global Centre for Democratic Constitutionalism. So today we're going to be discussing on the transformation of Mexican constitutional justice. For that reason, I'm really happy to have Micaela here. This is very important for me because I met Micaela when I was working in Mexico. I don't remember how many years ago, but before the pandemic. So that's the standard. And I think it's it is an honor for UCL. It's a privilege to have Micaela here. She's a professor in constitutional law at ITAM, Instituto Tecnológico, Autónomo, México. She holds a master's degree and a PhD in advanced studies on human rights from University Carlos III of Madrid. She has visited researcher at the Max Planck Institute for Comparative Public Law at Columbia University and the Institute of Legal Research of UNAM, Mexico. Her work focuses particularly on comparative constitutional law, constitutional design, democracy, political theory, human rights, gender studies, and feminism, with a particular focus on Latin American countries. She's also a member of the Council of ICONES, the International Society of Public Law. So the structure for the seminar is, Micaela, you will have up to 30 minutes for your presentation. I will let you know when you have like maybe 5 minutes left, so you can start finishing. And then we will open the floor for questions and comments. It is also online, just working, right? So yes, it's a hybrid event. So for people who want to make comments and questions, you have to put it on the chat, and then we can have this conversation also online. So Micaela, so yours, and whatever you need.
Well, thank you so much. Good afternoon, everyone, and thank you very much, Erin, Chris, for everything, and well, everyone responsible for the Sidney seminar here at UCL for the invitation and for organizing this roundtable. Thank you also to Natalia for wanting to chair my presentation, and to all those here for the interest in the constitutional reform that have recently taken place in Mexico, especially the one to the judiciary, that is the one I am about to comment on. And apologize for my English because it's not very fluent, but I will do my best. Well, I want to begin this discussion with a brief introduction to what is happening in Mexico and what I consider the key to understanding it. So I will make 3 general contextual approaches. First of all, Mexico has a constitution that dates back to 1917, but it has undergone nearly 800 reforms to its articles. Article 135 of the Constitution provides for the procedure to carry out constitutional reforms through the approval of 2/3 of each House of Congress and the following approval of more than half of the state legislatures, that are 32 in total. This procedure has no instance of popular participation or cooling off clauses and can be initiated by the executive branch. Although it seems to be an aggravated procedure that, due to the qualified majorities it requires, it has not worked that way in practice, because it is immersed in a system that we know as hyper-presidential, one where presidential power is predominant. In Mexico, in addition, due to the verticality of the party system, the president controls the member of his party both in Congress and the states. It is easy for him to generate alliances to carry out reforms. And I say him because, except for the current one, all presidents have been men. This procedure has allowed each Mexican president to carry out the constitutional reform he wanted, generating a constitution that does not have a clear identity, is one of the longest in the world, and is full of contradictions. In this sense, Mexico does not have a system of constitutional supremacy, since the Constitution has not served as an effective limit on power, but rather as the recipient of each 6-year political program. This has always been the case, no matter which party has governed. Added to this is the fact that the Supreme Court of Justice has not developed a doctrine of judicial review of constitutional amendments, neither formally nor materially. When the doctrine of the unconstitutional constitutional amendment began to be discussed, the possibility was expressly denied with the reform of the Amparo Law in 2013, although nothing was said about the possibility of using the other abstract forms of review. This is an open question. This design gives us the first key to understanding why constitutional reform to the judiciary has been possible, complying with the constitutionally established procedure at a time when Morena, the party of Andrés Manuel López Obrador, and the now President Claudia Sheinbaum, has supermajorities in Congress and governs more than half of the state of the Republic. The second contextual point is some background on the Supreme Court of Justice is important. As part of what was known as the transition to democracy in Mexico, which dates back to the 90s, the Supreme Court of Justice was reformed to become a sort of constitutional court. The court acquired abstract judicial review power and the power to resolve conflicts of competence between the branches of government. Also, its composition and duration were modified. In that reform, the appointment of the justices of the court was left in the hands of the executive. The process foresaw that the executive would propose a shortlist of 3 candidates for selection by the Senate. Still, if such a shortlist was rejected twice, the president could freely choose the incoming justice. This happened once with the last appointment of Lenia Batres by López Obrador. In addition, it was foreseen that the person who served as president of the Supreme Court would also preside the Council of the Judiciary, the institution in charge of the judicial career and the management of federal judicial. I don't have time to deep in this topic, but has a point in all the discussion in a broader sense. Other subsequent constitutional reform strengthened the role of the court in the constitutional framework, especially the 2011 reform of human rights, which, by amending Article 1 of the Constitution, established that human rights recognized in international treaties to which Mexico is a party have a constitutional hierarchy, and that, in case of conflict, they will be interpreted according to the pro persona principle. This reform, the 2011 reform, allowed, especially in the last 15 years, the court's jurisprudence to go from being formalistic and restrictive in the admission of cases alleging human rights violation to more protective and progressive in the defense of rights, especially those of a liberal nature, and to incorporate international standards of protection. It is important to note that this progress, compared with other Latin American courts, such as the Colombia or the Argentine courts, was quite timid and was not enough, for example, to generate robust protection for social rights or confront power. A third point of context is also important, even though it is controversial depending on one's view of constitutional justice. So this is my view. Since 1995, when this new, now old Supreme Court began to operate, it has had no major confrontation with the government in power, and as I said, it has taken a rather deferential and moderate attitude with them. Nor did it have any interest in building social legitimacy through its rulings, remaining in a position distant from the citizenry and not taking care to open up access to justice as far as possible, as we already know that this depends on the law of procedure, that is, on the legislative power. As a result, the citizenry knew little about the judiciary's work and identified it with the political power itself. This became a problem with the election of López Obrador in 2018, who, in his populist style, had no problem systematically presenting the court as the embodiment of the old politics, neoliberal, corrupt, and conservative, part of the mafia of power. This was part of the rhetoric of the president, the mafia of power, the mafia of power. So during the campaign, or before the election, López Obrador asked his listeners, and I quote, like literally, "Do you know of anything that those of the Supreme Court have done for the benefit of Mexico? Have you heard of anything they have resolved in favor of the people? Nothing." This, end of the quote, this starts the campaign. Not even 10 months into his presidency, he had already sent multiple projects to the legislative branch to try to reform the judicial branch constitutionally. One of the first attempts was to appoint court justices by popular votes. Others expanded the number of members of the court, created a constitutional tribunal that could acquire competencies that the court has until now, lowered salaries, etc. None of this passed at the time, but they would mark what were 6 years of continuous tensions between the executive and judicial branches. These tensions were pacified when the former justice, now Claudia Sheinbaum's advisor and one of the drivers of the Morenista judicial reform, Arturo Saldívar, assumed the presidency of the Supreme Court in January 2019. During his 4-year tenure, Saldívar tried to change the narrative regarding the judiciary and build some social legitimacy for it, getting closer to the executive branch. He used the idea of transformative constitutionalism, which aligned well with the government's narrative of building the fourth transformation for the country, accepting the diagnosis of very high level of impunity, corruption, and nepotism in the judiciary, and holding judges responsible for the poor results of their work. Faced with strong criticisms from the opposition to Morena and from internal opponents for the judiciary itself, who maintaining the narrative that the function of the judiciary should be to be a counter-majoritarian body and restrain the government. Saldívar took the idea, instead, of a collaborative constitutionalism in which all branches of government should work together to achieve progress in the realization of the Constitution and the transformation of the country. Thus, in 2021, he managed to carry out a minimal constitutional reform called With and For the Judiciary and calm the presidential anxiety to pack the court. I am using this background because I consider that these conflicting narratives about the role that the judiciary should play within a conception of separation of powers could have brought something constitutional positive for the country. Of myself, I write about this and I say, well, this is good, you know, we are talking about this. However, they were quickly truncated when unexpectedly Justice Norma Piña won the presidency of the court in 2023, the first female president of the court and a person openly opposed to the government. At that moment, the confrontation between the branches of power became evident again. The court, with an opposition majority, stopped specific public policies of special interest to the government. Among them, one with clear intention to disband the electoral body that clearly favored the party in power, the so-called Plan B in that moment, and the transfer of the National Guard, a kind of federal police in charge of public safety, to the command of the army, both very much celebrated in constitutional terms. However, the court also stopped other more debatable ones, such as the one that stopped the distribution of textbooks for public schools in 2 states due to complaints from the opposition, something that was clearly inadmissible, or suspended the application of the energy reform without a constitutional basis. The main problem with this last action, regardless of their qualification as good or bad, was that the court did not have the competence to suspend laws with general effects or dictate ruling with general effects within the amparo trial. Thus, the break on these public policies was through mechanisms of jurisprudential creation contra legem, absolutely. This more or less explains how we come to the point that on February 5 of last year, López Obrador sent to the Congress 18 constitutional reform initiatives, among them the one of the judicial branch, which he called Plan C. Other relevant initiatives in this package were, and I will say some because it's a huge package, the disappearance of 7 autonomous constitutional agencies and regulatory bodies, also called warrantor institution or the 4th branch, that had also been created in the 90s to try to diminish the country's hyper-presidentialism and guarantee certain fragile constitutional functions. Those were the National Institute for Transparency, Access to Information and Protection of Personal Data, the INAI, the Coneval, which was in charge of measuring the success of social programs and poverty in the country, the COFECE, which was the Federal Commission for Economic Competition, the Telecommunications Institute, the one for Educational Improvement, the Energy Regulatory Commission, and the Hydrocarbons Regulatory Commissions. The rationale for their disappearance was that they were expensive, duplicate functions already performed by the government, and were not as autonomous as they were said to be. Another constitutional amendment proposed was related to the expansion of crimes under the provision of automatic preventive detention. That is to say, because the accusation goes to a person for the alleged commission of one of these listed crimes, he or she must spend the proceeding in prison without the obligation for the prosecutor to prove that the accused person can alter the investigation or flee from justice. This has already been declared unconventional by the Inter-American Court of Human Rights in 2 cases against Mexico, which the government has decided not only to ignore, but extended the figure of this official pre-trial detention to more crimes. Also, there was an insistence on transferring the National Guard to the army. That reform was to complete the country's militarization, which even foresees tasks for the army and the navy in time of peace, such as managing public works, infrastructure works like the Mayan Train or the Felipe Ángeles Airport, etc. Other reform initiatives, although unnecessary, were more interesting, such as those related to substantive equality and the extension of rights of indigenous and Afro-descendant peoples and communities, already recognized in legislation and jurisprudence, but put in the Constitution, the prohibition of transgenic corn and animal abuse, for example, and other absurdities, such as the banning of vapors and electronic cigarettes. We have that in the Constitution, to name a few reforms that passed. That was proposed on February 5. So during the electoral campaign of now President Claudia Sheinbaum, the accusations against the court continue to rise. Judicial reform remained a latent threat until Morena not only won the election, but also obtained for its coalition supermajorities in Congress. Sheinbaum won with close to 60% of the votes, sufficient to carry out the constitutional amendment without the need to negotiate them with the opposition. There are details in the Mexican institutional design that were decisive at that time. The new Congress began functioning on September 1st, 2014, 2000, yes, 2004, okay. While the incoming president took office on October 1st. This month of difference was crucial for López Obrador to take advantage of the new majorities and accelerate the approval of the long-for judicial reform, which was officially published on September 15. Amid social protests and vote buying in the Senate to achieve the majority, they lacked 3 votes to have the required 2/3 parts. Extraordinary sessions to approve it in alternative venues, since the Congress was taking over, at a meteoric speed that generate not only very little reaction capacity, null reflection, but also some mistakes in the drafting that have generated numerous problems. Since then, the rest of the proposal have been gradually approved until they have all been implemented, just as the former president presented them. This has implied a complete change in the system of separation of power and a checkmate to rule of law. Now, the important thing, what does the judiciary reform consist of? Although the presidential rhetoric has been to democratize this power and clean it up, making it more independent, efficient, means faster, more legitimate, cheaper, or less privileged, and less corrupt, the truth is that nothing of the reform goes in that direction. Quite the contrary. The reform does not touch the current justice system in Mexico, which is integrated not only by the judiciary, but also by the prosecutor's office, the investigate police, the penitentiary system, and all the procedures that govern them, which, it is worth mentioning, has many of the defects that the president points out: high impunity rates, lack of access for the most vulnerable people, corruption, etc. What is mainly being reformed is the mechanism of access and permanence of judges, magistrates, and justices, making it more popular through popular vote. This will replace the total number of judiciary holders for a total of nearly 7,000 positions, some 1,700 of federal positions and those of the 32 local judiciaries in 2 elections. The first will be held on June 1st, now, in a month of this year, and it will be the largest election in Mexico's history, with 881 federal offices in dispute, with a total of 3,423 candidates. So we have to choose for 881 persons for the judiciary. And the second election will be held in 2027. Thank you. The Supreme Court will go from 11 members to 9 and only sit in plenary session, eliminating the chambers. Justices will serve for 12 years instead of 15 as at present. Re-election to their position is not allowed. In addition, the scope of their function was limited, expressly prohibiting both the suspension of legislation and ruling with general effect for them para trial. The qualified majority for any ruling now is of 6 out of 9 votes of justice that are still required to declare the laws unconstitutionality. The presidency of the court, which will last 2 years, will be held by the justice who obtained the most votes in the popular election and will be replaced at the end of the term with the next justice in number of votes and so on. As to how the judges, all of them, are selected, the fact that they are elected by popular vote is a half-truth. Before the ballot, there is a selection process for those who will be able to run. This is done using 3 evaluation committees, one for each branch of the state, made up of 5 persons that each branch designate discretionally, so we don't know who are these people, which in addition use the ballot, the lottery, a tombola, we say, to choose once the applicants have passed the suitability filter but exceed in number those who could be present in the electoral ballot. So if we have a lot of candidates that have the possibility to run, we choose who is going to run by ballot. No, it's ballot, yes, it's the sorteo is ballot, yes. A lottery, sorry. No ballot, lottery. Yes. The suitability requirements were relaxed. Knowledge exams were eliminated. There is no minimum age to apply, and only 5 years of experience is required to become a justice of the Supreme Court. For the rest, a 3-page essay and a 5 letters, no, really, no. It's a don't laugh, please. And 5 letters of preference from neighbors or acquaintance are needed. An average in law school of 8 out of 10. So you have to study at least whatever that law school is, because in Mexico we have like 3,000 law school without accreditation. It can also be from a master's degree or for a PhD, which rise to 9 from 10 for the specific subject of the position to which the person aspires. So if you go to criminal law, you have to have a 9 in criminal law, civil law, administrative law. Once this selection is complete, the nomination of candidates is left in the hands of the 3 branches of government, which send the final list to the Federal Electoral Institute. Thus, for the coming June election, the executive branch nominates 1/3 of the candidates, the legislative branch another third, and the Supreme Court was supposed to nominate the remaining third. Although it must be said that the court did not manage to complete the selection process, the persons who will run as judicial nominees were also nominated by the legislative branch. In addition to this nomination, the current incumbents for their position could run without going through the selection process. Who nominates its candidate is clearly stated on the ballot. So in the ballot, you are going to find the name of the person and the branch that nominates that person. Executive branch, legislative branch, judicial branch, or if you put former incumbent. So you have 4 kind of participants. From the outset, this guarantees Morena the nomination of 2/3 of the future incumbent so that the election is in the ballot. It is also worth mentioning that between 6 and 10 people, depending on the position, will be nominated for each vacancy to be filled. For that reason, is the 1,000 and 1,000 of persons, which means a ballot with a lot of names for the citizens to vote on, who will hardly have the tools to make an informed decision, since there is not only the ballot to elect the 9 ministers of the court, 5 women and 4 men, out of a total of 64 nominees, but there are 6 ballots in total for the other instance. So we must vote for the court, for the electoral court, for the disciplinary court, for the circuit magistrate, for the district judges, and then for the local judiciary. So when you go to vote, you have 6 different lists of names, and the court, only for the court, are 64 names, only for know who is running for the court. It should be known that there is no public money to finance campaign, nor its private financing allowed. There is only information on each candidate provided by the Electoral Institute and the donate spaces on television or radio that those with access have obtained. Most of the candidacies have been presented via social networks. But remember, we are dealing with thousands and thousands of names. Just listing the candidacies, putting only the names, yes, with no information, the INE have produced a 97-page document, only with the names. It is impossible to read, even those names. So from there to knowing who they are, it's like a word in between. Other issues that I would like to highlight before ending is that, yes, and I have to stop because I have 30 minutes. Is that the reform eliminates the Council of the Judiciary and it, in its place, establishes a Court of Judicial Discipline, which will also be elected by popular vote, whose function will be to control the good performance of the judiciary. Therefore, once the judges, magistrates, and justices are appointed, they will be subject to the control and appealing sanction of this tribunal, threatening their independence. It should be known that the position of judges and magistrates lasts 9 years with the possibility of re-election, which adds another incentive to be deferential to political power. Finally, the judicial reform allows for establishing faceless judges for cases that could jeopardize the judge's safety. For example, in organized crime. This violates all guarantees of due process and contradicts the very purpose of the reform, that the citizenry should know and choose their judges. In short, the judicial overhaul, which is more a constitutional replacement than a reform, is majoritarian but not democratic. There is no provision for any accountability by citizenry, and there is no opening of any kind for people in situation of greater vulnerability to have access to justice. In fact, there are no changes in the procedures except for shortening the old deadline, undermines judicial independence, scores the professionalization of the function, which undermines the efficiency in the administration of justice, breaks with the division of power and the possibility of check and balances to the political power, and opens many cracks to suspect that it will lead to greater degrees of corruption, co-optation by private interests that can mobilize people to vote or finance campaigns, between them organized crime. This is not only serious, but also inaugurates a new regime for the Mexican state, the consequences of which are still difficult to foresee, but which seem illiberal, without limit to power, nationalist, as it has rejected international condemnation to human rights violation and in general denies any interference, and hyper-presidential. This clearly exemplifies what Dixon and Landau call abusive constitutionalism, or Kinlan-Chappell call autocratic legalism. Unfortunately, it followed the trend of democratic regression via constitutional reform that we have already seen in other countries, which undermine the minimum democratic nucleus by eliminating check and balances to power. In order not to end with so much regret, and if it were not for the very high cost that we will have to pay for all this, the sociopolitical and juridical experiment that it means is at least interesting and challenging. As otherwise, we are going to kill ourselves. No? As constitutionalists, we will be witnessing, for the first time, a complete system of popular appointment of judges, which promises gender parity, and a complete change in the legitimation of the judicial branch, which abandon the expertise ground. We will see what consequences it brings, what profile of judges it achieves, what kind of constitutional interpretation it generates, and what dynamics of relationship with the other branches it initiates. Since it is naive to think that it will be only of coercion by Morena, given that now the judicial branch will also have democratic legitimacy and that there are several de facto powers that will be able to acquire their own judges, as well as other political parties in the states where Morena does not have majorities. So we don't know really what's going to happen. Finally, we will see how the population's access to justice will be configured and the support they will give to the branch, among other things. We will see. Thank you very much for the attention, and I remain attentive.
And for those of you here, please join us on May 15th for our next Sidney seminar, which will be Gabrielle Appleby in person. And I'm not sure if there's do we know if she's going to have a co-author online?
Yes.
Yeah, okay. I'm sorry, I didn't want to. Presenting on the Australian First Nations voice efforts and the failure of expanding representation through the voice. So a little bit about Australia to come after this. So thank you very much.
Thank you very much.
And thank you, everyone.
Thank you. Thank you so much.